The Supreme Court on Monday stepped in to arrest what it described as a legally troubling development in one of India's most disturbing criminal cases, staying the Delhi High Court's order that had granted bail to former BJP MLA Kuldeep Singh Sengar in the Unnao rape case. The top court's intervention ensures that Sengar, who stands convicted of raping a minor and has been sentenced to life imprisonment, will not be released from jail even temporarily. A bench led by Chief Justice of India Surya Kant said the matter raised substantial questions of law that required careful examination. While courts ordinarily avoid staying bail or suspension of sentence orders without first hearing the accused, the bench said this case involved peculiar and exceptional facts that justified immediate intervention. The court noted that Sengar continues to remain behind bars because of his conviction and sentence in another criminal case arising from the same chain of events, making the High Court's decision all the more consequential. The CJI expressed serious concern over whether the High Court had even examined Sengar's conviction under Section 376 of the IPC while granting relief. The bench also questioned the interpretation adopted under the Protection of Children from Sexual Offences Act, warning that it could lead to illogical and unintended consequences. The court pointed out that under the reasoning adopted, even lower level officials such as constables or patwaris could be treated as public servants for the purpose of aggravated offences, while elected representatives like MLAs or MPs could potentially escape that classification. Such an outcome, the bench suggested, would run counter to both legislative intent and common sense. The court further clarified that amendments to the POCSO Act were intended to enhance punishment for existing offences and not to create new categories of offences through strained interpretation. At the same time, the bench struck a note of institutional humility, acknowledging that judges, like all institutions, are capable of error and that judicial scrutiny is a vital safeguard within the legal system. However, it firmly rejected the idea of publicly browbeating courts or turning legal disagreements into street-level campaigns, a remark widely seen as a caution against trial by media and public pressure. For the survivor, whose counsel sought permission to intervene during the hearing, the court clarified that she did not require leave to challenge the High Court's order. She has an independent statutory right to file a separate special leave petition, the bench said, adding that free legal assistance would be made available through the Supreme Court Legal Services Committee if she chose to avail it. For now, the Supreme Court's message is unmistakable. In cases where power, violence, and justice collide, legal shortcuts will not be allowed to go unquestioned.